Hello and welcome to Bar10 Test Prep, Day 7 or Lesson 7, where it's our goal to prepare you for the bar exam 10 questions at a time. Please like, subscribe, and hit the notification bell so that you can be updated every time we upload new content. Question number 1. Alex and Betty, who were cousins, acquired title and fee simple to Blackacre as equal tenants in common by inheritance from Angela, their aunt. During the last 15 years of her life, Angela allowed Alex to occupy an apartment in the house on Blackacre, to rent the other apartment in the house to various tenants, and to retain the rent. Alex made no payments to Angela, and since Angela's death 7 years ago, he has made no payments to Betty. For those 22 years, Alex has paid the real estate taxes on Blackacre, kept the building on Blackacre insured, and maintained the building. At all times, Betty has lived in a distant city and has never had anything to do with Angela, Alex, or Blackacre. Recently, Betty needed money for the operation of her business and demanded that Alex join her in selling Blackacre. Alex refused. The period of time to acquire title by adverse possession in the jurisdiction is 10 years. There is no other applicable statute. Betty brought an appropriate action against Alex for partition. Alex asserted all available defenses and counterclaims. In that action, the court should A. Deny partition and find that title has vested in Alex by adverse possession. B. Deny partition, confirming the tenancy in common, but requiring an accounting to determine if either Betty or Alex is indebted to the other on account of the rental payment, taxes, insurance premiums, and maintenance costs. C. Grant partition and require as an adjustment an accounting to determine if either Betty or Alex is indebted to the other on account of the rental payments, taxes, insurance premiums, and maintenance costs. Or D. Grant partition to Betty and Alex as equal owners, but without an accounting. Take 10 seconds and see what you think is the best answer. If you chose C, grant partition and require an adjustment and accounting to determine if either Betty or Alex is indebted to the other on account of the rental payments, taxes, insurance premiums, and maintenance costs, you'd be correct. In the tenancy in common, each tenant has an undivided interest in the property with no right of survivorship. One of the rights of a co-tenant is to bring an action for partition. In bringing an action for partition, a court will require an accounting between the tenants in common relating to the property. Here, both Alex and Betty had a right as tenants in common to bring an action of partition. Betty did so, and the court will require an accounting between Alex and Betty relating to Blackacre to ensure the property's division is fair. For example, Alex never made rental payments to Betty, but Alex did pay real estate taxes, insurance, and maintenance. Therefore, the court should grant partition and require, as an adjustment, an accounting to determine if either Betty or Alex is indebted to the other on account of the rental payments, taxes, insurance premiums, and maintenance costs. Question number 2. Karen was crossing Main Street at a crosswalk. John, who was on the sidewalk nearby, saw a speeding automobile heading in Karen's direction. John ran into the street and pushed Karen out of the path of the car. Karen fell to the ground and broke her leg. In an action for battery brought against Karen against John, will Karen prevail? A. Yes, because John could have shouted a warning instead of pushing Karen out of the way. B. Yes, if Karen was not actually in danger and John should have realized it. C. No, because the driver of the car was responsible for Karen's injury. Or D. No, if John's intent was to save Karen, not to harm her. Take 10 seconds and see what your choice is. If you chose B, yes, if Karen was not actually in danger and John should have realized it, you'd be correct. Battery is the intentional infliction of a harmful offensive touch with a victim's person. Contact is offensive if a reasonable person would not have consented to the contact. Consent can be implied from the plaintiff's conduct or from circumstances, e.g., for example, the action was necessary to save the plaintiff's life. In this case, John saw a speeding automobile heading in Karen's direction, so he ran into the street and pushed her out of the path of the car, assuming that Karen's life was actually in danger. Karen's consent to this contact would be implied from the circumstances. Therefore, in any action for battery brought by Karen against John, Karen would only prevail if Karen was not actually in danger and John should have realized it. Question number 3. Rachel, an antique dealer and a skilled calligrapher, crafted a letter on very old paper. She included details that would lead knowledgeable readers to believe the letter had been written by Thomas Jefferson to a friend. Rachel, who had a facsimile of Jefferson's autograph, made the signature and other writing on the letter resemble Jefferson's. She knew that the letter would attract the attention of local collectors. When it did, and she was contacted about selling it, she said that it had come into her hands from a foreign collector who wished anonymity, and that she could make no promises about its authenticity, as she had hoped a collector paid her $5,000 for the letter. Later, the collector discovered the letter was not authentic, and handwriting analysis established that Rachel had written the letter. In a jurisdiction that follows common law definition of forgery, Rachel has A. committed both forgery and false pretenses, B. committed forgery because she created a false document with the intent to defraud, but has not committed false pretenses since she made no representation as to the authenticity of the document. C. Not committed forgery because the document had no apparent legal significance, but has committed false pretenses since she misrepresented the source of the document. D. Not committed forgery because the document had no apparent legal significance and has not committed false pretenses since she made no representation as to the authenticity of the document. Which choice do you think is the best? If you chose C, you'd be correct. Not committed forgery because the document had no apparent legal significance, but has committed false pretenses since she misrepresented the source of the document. Forgery requires making or altering a writing with apparent legal significance so that it is false and with a specific intent to defraud. False pretenses, however, requires obtaining title to another's personal property by an intentional false statement of past or present fact with a specific intent to defraud. In this case, Rachel crafted a letter that looked like it was from Thomas Jefferson to a friend. She knew the letter would look authentic and attract the attention of local collectors. She was acting with the specific intent to defraud collectors. However, since the letter she crafted was between Thomas Jefferson and his friend, it carried no apparent legal significance, unlike, let's say, for example, a forged check or a driver's license. Because the letter carried no legal significance, Rachel has not committed forgery. However, Rachel is not totally absolved since she obtained $5,000 from a collector by intentionally making the false statement that the letter was from an anonymous foreign collector when she was actually the one who crafted the letter herself. She acted with the specific intent to defraud collectors by crafting this fake letter so that Rachel has in fact committed false pretenses. Question number 4. By the terms of a written contract signed by both parties on January 15th, MB RAM Incorporated agreed to sell a specific ICB personal computer to Marilyn Matterboard for $3,000, and Matterboard agreed to pick up and pay for the computer at RAM's store on February 1st. Matterboard unjustifiably repudiated on February 1st. Without notifying Matterboard, RAM subsequently sold at private sale the same specific computer to Byte, who paid the same price, $3,000 in cash. The ICB is a popular product. RAM can buy from the manufacturer more units than it can sell at retail. If RAM sues Matterboard for breach of contract, RAM will probably recover A, nothing, because it received a price on resale equal to the contract price that Matterboard had agreed to pay. B, nothing, because RAM failed to give Matterboard proper notice of RAM's intention to resell. C, RAM's anticipated profit on the sale to Matterboard, plus incidental damages, if any, because RAM lost that sale. $3,000, the contract price, because Matterboard intentionally breached the contract by repudiation. Which do you think is the best choice? You have 10 seconds to decide. The best answer is C. RAM's anticipated profit on the sale to Matterboard plus incidental damages, if any, because RAM lost that sale. Under the UCC, a volume seller can recover provable lost profits. This occurs when the contract was for goods of regular inventory that are not unique. The idea is that had the original buyer not breached the contract, the seller would have made two sales. So courts allow sellers to recover the lost profits on the lost sale due to the breach. In this case, Maryland Matterboard agreed to purchase an ICB personal computer from NB RAM Incorporated. The ICB is a popular product that RAM can buy from the manufacturer more units than it can sell at retail. As such, RAM would qualify as a volume seller, so RAM could recover the profits lost from Maryland Matterboard's breach. Question number 5. Congress recently enacted a statute imposing severe criminal penalties on anyone engaged in trading in the stock market who, in the course of that trading, takes unfair advantage of other investors who are also trading in the stock market. The statute does not define the term unfair advantage. There have been no prosecutions under this new statute. The members of an association of law school professors that is dedicated to increasing the clarity of the language used in criminal statutes believe that this statute is unconstitutionally vague. Neither the association nor any of its members is currently engaged in or intends in the future to engage in trading in the stock market. The association and its members bring suit against the Attorney General of the United States in a federal district court, seeking an injunction against the enforcement of this statute on the grounds that it is unconstitutional. May the federal court determine the merits of this suit? A. Yes, because the suit involves a dispute over the constitutionality of a federal statute. B. Yes, because the plaintiffs seek real relief of a conclusive nature and injunction against enforcement of the statute. C. No, because the plaintiffs do not have an interest in the invalidation of the statute that is adequate to ensure that the suit presents an Article 3 controversy. D. No, because a suit for an injunction against enforcement of a criminal statute may not be brought in federal court at any time prior to a bona fide effort to enforce that statute. Which option do you think is the best? You have 10 seconds to decide. The best choice is C, no, because the plaintiffs do not have an interest in the invalidation of the statute that is adequate to ensure that the suit presents an Article 3 controversy. The rule for association standing is that an organization may sue on behalf of its members if 1. Individual members have standing to sue. Here, clearly, based on the facts, none of the individual members have standing to sue. 2. Interests related to the purpose of the organization, which theoretically, yes, this might meet. And 3. Neither claim nor relief requires participation of individual members. Standing generally requires an injury, causation, and redressability. In this case, the individual members of an association of law school professors would not have standing to challenge the law because neither the association nor any of its members is currently engaged in or intends in the future to engage in trading in the stock market. The members have not suffered, nor will they suffer, any injury, and therefore the federal court cannot determine the merits of this suit. Let's move on to question number 6. At Dove's trial for theft, Mr. Wong, called by the prosecutor, testified to the following. 1. That from his apartment window, he saw thieves across the street break the window of a jewelry store, take jewelry, and leave in a car. 2. That Mrs. Wong telephoned the police and relayed to them the license number of the thieves' car as Mr. Wong looked out the window with binoculars and read it to her. 3. That he has no present memory of the number, but that immediately afterward he listened to a playback of the police tape recording giving the license number, which belongs to Dove's car, and verified that she had relayed the number accurately. Playing the tape recording for the jury would be A. Proper, because it is recorded recollection. B. Proper, because it is a public record or report. C. Improper, because it is hearsay not within any exception. Or D. Improper, because Miss Wong lacked first-hand knowledge of the license number. Take 10 seconds to choose the best answer. The best answer would be A, proper, because it is a recorded recollection. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in the statement. The hearsay exceptions under the Federal Rules of Evidence are 1, admission of a party opponent, 2, vicarious party admissions, and 3, prior statements by witnesses. The hearsay exceptions generally are also hearsay but is admissible are 1, excited utterance, 2, present sense impression, 3, present state of mind, 4, statements of past or present mental or physical condition made for a medical diagnosis or treatment, 5, business records exception, 6, public records exception, and 7, judgments of previous conviction. In this case, Ms. Wong telephoned the police and relayed to them the license number of the thief's car as Mr. Wong looked out the window with binoculars and read it to her. These are clearly out-of-court statements, so they would be inadmissible if offered to prove the truth of the matter asserted, i.e. the license number of the thief's car, unless one of the exceptions applies to both statements, since Mr. Wong was describing the thief's license plate number as he was perceiving it with binoculars, and Ms. Wong relayed this information to the police as Ms. Wong did so. Both of these exceptions would fall under the hearsay exception of present sense impression, and as such, the recording would be admissible. Question number 7. Janet had a season ticket for the Scorpions hockey games at Central Arena, Section B, Row 12, Seat 16. During the intermission between the first and second periods of a game between the Scorpions and the visiting Hornets, Janet solicited signatures for a petition urging that the coach of the Scorpions be fired. Central Arena and the Scorpions are owned by ABC Incorporated, a privately owned entity. As evidenced by many prominently displayed signs, ABC prohibits all solicitations anywhere within Central Arena at any time and in any manner. ABC notified Janet to cease her solicitation of signatures. Janet continued to seek signatures on her petition during the Scorpions' next 3 home games at Central Arena. Each time, ABC notified Janet to cease such solicitation. Janet announced her intention to seek signatures on her petition again during the Scorpions' next home game at Central Arena. ABC wrote a letter informing Janet that her season ticket was canceled and tendering a refund for the unused portion. Janet refused the tender and brought an appropriate action to establish the right to attend all the home games. In this action, the court will decide for A, ABC, because it has a right and obligation to control activities on realty it owns and has invited the public to visit. B, ABC, because Janet's ticket to hockey games created only a license. C, Janet, because having paid value for the ticket, her right to present cannot be revoked. D, Janet, because she was not committing a nuisance by her activities. Take 10 seconds and choose the best answer. Best answer would be B, ABC, because Janet's ticket to a hockey game created only a license. A license is the mere privilege to use another's land for a specified purpose. For example, tickets. Generally, a license is revocable at the will of the licensor at the game at any time. In this case, Janet's season ticket is a license that is revocable at the will of ABC at any time. ABC decided to cancel Janet's ticket when she continued to solicit signatures despite the posted signs prohibiting solicitation and repeated warnings to cease such solicitation. Janet's license to attend home games has been properly revoked. Accordingly, the court will decide for ABC because Janet's ticket to a hockey game created only a license. Question number 8. Perry suffered a serious injury while participating in an impromptu basketball game at a public park. The injury occurred when Perry and Deaver, on opposing teams, each tried to obtain possession of the ball when it rebounded from the backboard after a missed shot at the basket. During that encounter, Perry was struck and injured by Deaver's elbow. Perry now seeks compensation from Deaver. At the trial, evidence was introduced tending to prove that the game had been rough from the beginning, that elbows and knees had frequently been used to discourage interference by opposing players, and that Perry had been one of those making liberal use of such tactics. In this action, will Perry prevail? A, yes, if Deaver intended to strike Perry with his elbow. B, yes, if Deaver intended to cause a harmful or offensive contact with Perry. C, no, because Perry impliedly consented to rough play. D, no, unless Deaver intentionally used force that exceeded the player's consent. Take 10 seconds and choose the best answer. Best answer is D. No, unless Deaver intentionally used force that exceeded the player's consent. Battery is an intentional infliction of a harmful or offensive contact with the victim's person. Consent is a valid defense to battery. Consent may be express or implied. Consent may be implied from the victim's conduct, custom, or from the circumstances. Apparent consent exists in activities where minor invasions are routine, for example, playing pickup basketball. However, even if there is consent, a defendant will nevertheless be liable if his actions go substantially beyond the scope of the consent. In this case, apparent consent to contact exists in pickup basketball because minor invasions are routine. This particular game was rough from the beginning, so continuing to play in the game implied consent to the rough contact. However, even with the apparent consent to a rough and physical game, Deaver would still be liable for battery if his actions went substantially beyond the scope of the consent. Therefore, Perry will not prevail unless Deaver intentionally used force that exceeded the player's consent. Question number 9. Nora, executive director of an equal housing opportunity organization, was the leader of a sit-in at the offices of a real estate management company. The protest was designed to call attention to the company's racially discriminatory rental practices. When police demanded that Nora desist from trespassing on the company's property, she refused and was arrested. In Nora's trial for trespass, the prosecution preemptorily excused all non-whites from the jury, arguing to the court that even though Nora was white, minority groups would automatically support Nora because of her fight against racism in housing accommodations. If Nora is convicted of trespass by an all-white jury and appeals claiming a violation of her constitutional rights, the court should A. affirm the conviction because Nora was not a member of the class discriminated against, B. affirm the conviction because preemptory challenges of non-whites did not deny Nora the right to an impartial jury, C. reverse the conviction because racially based preemptory challenges violate equal protection of the law, or D. reverse the conviction because Nora was denied the right to have her case heard by a fair cross-section of the community. You have 10 seconds to choose the best answer. If you chose C, reverse the conviction because racially based preemptory challenges violate equal protection of the law, you'd be correct. It's unconstitutional for potential jurors to be excluded by the prosecution or defense on the basis of race or gender. In this case, the prosecution peremptorily excused all non-whites from the jury on the basis of race, so the court should reverse the conviction. Question number 10. In a single writing, Painter contracted with Farmer to paint 3 identical barns on her rural estate for $2,000 each. The contract provided for Farmer's payment of $6,000 upon Painter's completion of the work on all 3 barns. Painter did not ask for any payment when the first barn was completely painted, but she demanded $4,000 after painting the second barn. Is Farmer obligated to make the $4,000 payment? Option A, no, because Farmer has no duty under the contract to pay anything to Painter until all 3 barns have been painted. B, no, because Painter waived her right, if any, to payment on a per-barn basis by failing to demand $2,000 upon completion of the first barn. C, yes, because the contract is divisible. D, yes, because Painter has substantially performed the entire contract. Take 10 seconds and choose the best option. The best option here is no, A, because Farmer has no duty under the contract to pay anything to Painter until all 3 barns have been painted. Divisible contracts involve the same act being performed a certain number of times, and the performer is paid on a per-performance basis. If, however, the parties expressly contract that payment is to be made after performance is completed, the contract will be not divisible. At first glance, this contract seems to be divisible because of the 3 identical barns being painted for $2,000 each. However, the contract provided for Farmer's payment of $6,000 upon Painter's completion of the work on all 3 barns. The contract cannot be divisible because of the express language that payment will be made upon Painter's completion of work on all 3 barns. Therefore, Farmer is not obligated to make the $4,000 payment because farmer has no duty under the contract to pay anything to painter until all 3 barns have been in fact painted. Again, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Please remember to like, subscribe, and click the notification bell so that you can be notified every time we upload new content.